Part 5, Realm and Commonwealth by Spiers. Copyright 2018. Post-Federation, the people were urged to come up with designs for a flag by the newly formed Parliament. Taking its first sitting on the 9th of May 1901 at the House of Parliament in Melbourne, Victoria, representatives and ministers posed to put it to the people to design a flag. This was advertised in newspapers across the country and entries taken for the development of a federal flag. By September 1901, a design had been chosen and shown off to the people of the Commonwealth of Australia. This newly accepted federal flag was then adopted as the national flag of the Commonwealth of Australia. The design featured the Union Jack in the upper left canton, with a 6-pointed white star filling the lower left canton, with the rest of the field emblazoned with the stars of the Southern Cross, increasing in number from 5 to 9 anti-clockwise. This was used as a red ensign and adopted as the national flag, backed in blue for use by government only. We can see by postcards issued in 1908 on the arrival of the United States fleets to Sydney Harbour that the Great Seal of the Commonwealth under Edward VII features centred the difference to the Great Seal of the Commonwealth of Australia issued to George V is noted in newspaper articles at the time of the issuance of the Great Seal of the Commonwealth of Australia to King George V. When compared to the second postcard printed in 1908, we see the red ensign this time with a clearly shown 6-pointed star in white with the lion of the motherland, the kangaroo and the emu, and the eagle of the United States. The national pride shown for this newly formed Commonwealth in the realm can be demonstrated in many places. The Anzac fought under this flag, as can be seen here with Breaker Morant's military gear laid out for display. Men and women alike honoured the flag of their newly founded Commonwealth of Australia. Anzac had fought valiantly, spilling blood and losing life, so that you may leave future birthright to your children in the benefits of a free society held in trust and estate to provide a beneficial interest to those in allegiance with and defence of the realm that provided the ability to be that people. Henry Parkes had helped to create an indissoluble federal Commonwealth of Australia under the blessing of Almighty God, under the realms of the United Kingdom of Great Britain and Ireland, born of the will of the Father through testament of his sons, those sons of the Commonwealth sacrificing life, so that you may have a way of life born from the Christianity of the authorised King James Bible, given to you by King James I after Henry VIII had extirpated the Catholic Church from the realm. The people of this newly formed Commonwealth were proud. They had separated from the motherland to become her son. They had built something for the future generations and sealed it in self-determination on an international stage. This is something that Tibet failed to do against China, yet Israel succeeded to manage across Palestine. You can see that self-determination means coming to peace in a larger theatre involving warfare. We can see here by this small newspaper clipping that the flag adopted by the national government was brought into question and before the Attorney General. We also make very important note that it mentions legal consideration of the Attorney General according to Imperial law. In June 1903, King Edward VII, as commander and head of the Imperial forces, issued royal warrant for use of flag by the Commonwealth of Australia, authorising the protection of Commonwealth vessels in open waters. Royal warrant declared that vessels registered could fly red ensign with Southern Cross emblazoned with a single 5-pointed star with 7 pointed stars for the 4 main pointers. This became the flag of His Majesty's naval fleets and was authorised protections by His Majesty's Navy in open waters while doing trade. And whereas by warrant under our hands dated this 4th day of June 1903, vessels registered in the Commonwealth of Australia are authorised to fly the red ensign of His Majesty's fleet, defaced as follows, viz. By command of their Lordship, SD. Evan McGregor. Now, therefore, we do by virtue of the power and authority vested in us hereby warrant and authorise, registered in the Commonwealth of Australia, to fly the red ensign of His Majesty's fleet, defaced as heretofore, except that the white 7-pointed star shall be substituted for the white 6-pointed star in the centre of the lower canton next the staff. Given under our hands and the seal of the Office of Admiralty this 3rd day of October 1908. Military order were issued in 1908 to change the lower canton 6-pointed star and royal warrant issued by Edward VII to reflect the change and pass this change onto the protection of civil merchant vessels under the auspices of His Majesty's naval fleets. This is very important given several observations such as the coat of arms displayed on the Royal Australian Naval Band sash displaying 6-pointed star, as well as the 7-pointed star replacing the Imperial crown on the florin turned 50-cent round and eventually sided coin. Later, in 1936, the Admiralty of the Commonwealth of Australia indicates the usage of white and blue ensigns within the Commonwealth and abroad. This aligns with the Statute of Westminster Act UK 1931, which brings into question the actions surrounding the Statute of Westminster Adoptions Act, Commonwealth 1942. We will investigate this in the next sections of this paper. What is clear to note under Admiralty order is that the white and blue ensigns of His Majesty's fleets are purely maritime flags. The white ensign establishes the headship linked to the land by way of maritime barracks, and the use of the blue and white ensign on shore other than for maritime purposes is improper. The white ensign is nothing else but the national colours of a ship of war in commission, meaning that it is in active service and ready to be put to war and therefore a current ship of war. We can see by this postcard printed in November 1914 that at the declaration of participating in World War I, that the Australian Naval Fleet was entering its first theatre of active warfare under a blue ensign with a 6-pointed star. This is post changes by military order to fly a blue ensign with a 7-pointed star as previously noted. Looking at what we call the Aboriginal flag, we also take note of Cathy Freeman flying 2 flags at the Olympic Games. This triggered the release of a government press release from the Minister for Aboriginal Affairs declaring the Aboriginal flag an Australian national flag. Previously under copyright, it had now gained the status of a national flag. We now have one nation flying 2 separate flags that both represents the same thing, in that they fall under the Australian government, which in its own flag is displaying a 7-pointed star in its lower canton. The division of a people under 2 flags that behind we have defined as meaning the same thing. Aboriginals are considered to be Australian citizens, as in the general populace of the Australia. Stamped 30th of December 2004. A letter from the Minister of Aboriginal Affairs, the Honourable Gavin Jennings MLC, to Mr. Peter Pape Manulpul, President, the Australian National Flag Association Incorporated. Dear Mr. Papa Manurapul, Promotion of the Australian Aboriginal Flag. Thank you for your email of 17 November 2004 about the use of the Australian Aboriginal flag. As you know, the Australian Aboriginal flag was proclaimed as a flag of Australia under Section 5 of the Flags Act 1953 on 14 July 1995. Mr. Harold Thomas, an Aboriginal elder, was later recognised as the designer of the Aboriginal flag by the Federal Court and was given a backdated copyright to the design to 1971. In 1998, Mr. Thomas awarded an exclusive licence for the manufacture and marketing of Aboriginal flags, banners and bunting to Carroll and Richardson Flags. I am advised that the Australian Aboriginal flag is not a privately controlled and commercialised product. It is a proclaimed flag of Australia that differs from other flags of Australia in that the individual holder of the copyright of the design is recognised. The Commonwealth Flag Officer from the Department of Prime Minister and Cabinet advises that the Australian national flag may be used for commercial or advertising purposes without formal permission, subject to published guidelines. In contrast, any commercial use of the Australian Aboriginal flag would be subject to the restrictions imposed by Harold Thomas Copyright and Licence Agreement. The Aboriginal and Torres Strait Islanders flags are normally flown where the event or location has a specific Aboriginal or Torres Strait Islander connection, and they should only be flown by other Australians when permission has been granted and in accordance with Australian official protocol in terms of precedence. Yours sincerely, signed, Gavin Jennings, MLC, Minister for Aboriginal Affairs. We have seen two realms at play, and we know that one is born from Queen Victoria and the Imperial crown, but now we have a second realm, or realms, being headed under Queen Elizabeth II and the St. Edward's crown. Yet we don't see this change in crown until the coronation of Queen Elizabeth II in 1953. Queen Victoria set a legacy in her own right through an imperial crown, and now we have a Queen Elizabeth II being crowned at coronation with a crown that hadn't been heard of since the times of Oliver Cromwell, when the parliamentarians of the day saw the crown stolen not only once but twice. During both thefts, the jewels were stolen and never recovered. The gold was melted down, and at the second theft, not recovered either. Coronation of Queen Victoria on unknown date, 1937. Archbishop, will you solemnly promise and swear to govern the people of this kingdom of England and the dominions thereto belonging according to the statutes in Parliament agreed on and the laws and customs of the same? Queen, I solemnly promise so to do. Coronation of Queen Elizabeth II on 2nd of June 1953. Archbishop, will you solemnly promise and swear to govern the peoples of the United Kingdom of Great Britain and Northern Ireland, Canada, Australia, New Zealand, the Union of South Africa, Pakistan and Ceylon, and all your possessions and other territories, to any of them belonging or pertaining according to their respective laws and customs? Queen, I solemnly promise so to do. We can see here that when the Queen took her solemn oath to the realm, it is very clearly to that of the renamed Parliament of the United Kingdom of Great Britain and Northern Ireland. We make note that the Parliament was renamed in 1927, yet George V, in style and title, split the kingdom, being Great Britain, Ireland and. What exactly is the Queen taking coronation to? It should all be noted that in her coronation oath, she takes to govern the peoples of Australia separately and lists them along with other possessions and territories. Royal Powers Act 1953, Section 2. Exercise of statutory powers by the Queen. 1. At any time when the Queen is personally present in Australia, any power under the Act exercisable by the Governor-General may be exercised by the Queen. 2. The Governor-General has the same powers with respect to an act done or an instrument made, granted or issued by the Queen by virtue of this section as the Governor-General has with respect to an act done or an instrument made, granted or issued by the Governor-General himself or herself. 3. Nothing in this section affects or prevents the exercise of any power under an act by the Governor-General. 4. In this section, references to the Governor-General or to the Queen shall be read as references to the Governor-General or to the Queen, acting with the advice of the Federal Executive Council. The first question to ask here is, why did Queen Elizabeth II install Royal Powers Act 1954, when Edward VII and George V did not, when following in ascension after Queen Victoria? As can be seen, the Act confers power to the Queen through the Governor-General at Section 2-1, followed by powers issued to the Governor-General from the Queen at Section 2-2. Herein we also have reference to the Federal Executive Council, which is formed in Section 62 of the Constitution at Clause 9 of the Commonwealth of Australia Constitution Act July 1900 UK/PGA, to advise the Governor-General, and comprises, at least notionally, all current and former Commonwealth ministers and assistant ministers. As the Governor-General is bound by convention to follow the advice of the Executive Council on almost all occasions, the Executive Council has de jure executive power. This power is used to legally enact the decisions of the Cabinet, the de facto body of executive power, which under conventions by the Westminster system has no de jure authority. In practice, the Federal Executive Council meets solely to endorse and give legal force to decisions already made by Cabinet. The Federal Executive Council is the Australian equivalent of executive councils in other Commonwealth realms, and is similar to the Privy Councils of Canada and the United Kingdom, although unlike the UK Privy Council, the Leader of the Opposition is not typically a member. In 1971, the Prime Minister's Department and the Department of the Cabinet Office was abolished. This saw the abolition of the Secretary to the Prime Minister, the Secretary to the Department of Cabinet, and all subdivision departments of these two offices. These two offices were then replaced with the Department of the Prime Minister and Cabinet and the Department of the Vice President of the Executive Council, followed by the offices of the Secretary to the Department of Prime Minister and Cabinet, and the offices of the Secretary to the Department of the Vice President of the Executive Council. This we will address again later. For now, we can see that Queen Elizabeth needed advice from the Executive Council to confer powers through the Governor-General from a realm foreign. In the same, the Queen is given powers in the Governor-General from his current authority as Governor-General of the United Kingdom of Great Britain and Ireland, with powers vested in the office of Governor-General, along with the Great Seal of the Commonwealth of Australia, conferred through Letters Patent 1900 of Queen Victoria, and the Commonwealth of Australia Constitution Act July 1900 UK/PGA, under the United Kingdom of Great Britain and Ireland, as detailed in Acts Interpretation Acts 1966. And backed up by Great Seal of the Commonwealth of Australia under King George V and Great Seal of New South Wales under King George VI. When looking at this, it is very easy to glance over a very specific point of treason when you discuss the Oath of Allegiance and the Crown realm that it stems from, noting that heirs and successors are relative to royal law and a birthright in which is passed on. We have already discussed how we come to recognise the line of authority in which the Commonwealth of Australia was born, stemming from Queen Victoria and handed to Edward VII and George V. We know from the preamble to the Commonwealth of Australia Constitution Act, July 1900 UK/PGA, that we are speaking of the United Kingdom of Great Britain and Ireland. To be noted as of key importance is the Oath of Allegiance in the schedule to the Commonwealth of Australia Constitution Act July 1900 UK/PGA is to the monarch, It is through the monarch that the realm is anchored to the crown. Commonwealth of Australia Constitution Act, Schedule Oath. I, AB, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. So help me God. Affirmation. I, AB, do solemnly and sincerely affirm and declare that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. Note, the name of the King or Queen of the United Kingdom of Great Britain and Ireland for the time being is being substituted from time to time. Commonwealth of Australia Constitution Act, Section 42. Oath or affirmation of allegiance. Every senator and every member of the House of Representatives shall, before taking his seat, make and subscribe before the Governor-General or some person authorised by him an oath or affirmation of allegiance in the form set forth in the schedule to this Constitution. Commonwealth of Australia Constitution Act, Section 44. Disqualification. Any person who 1. Is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or a citizen or entitled to the rights or privileges of a subject or a citizen of a foreign power, or 2. Is attainted of treason or has been convicted and is under sentence or subject to be sentenced for any offence punishable under the law of the Commonwealth or of a state by imprisonment for 1 year or longer, or 3. Is a undischarged bankrupt or insolvent, or 4. Holds any office of profit under the Crown, or any pension payable during the pleasure of the Crown out of any of the revenues of the Commonwealth, or 5. Has any direct or indirect pecuniary interest in any agreement with the public service of the Commonwealth otherwise than as a member or in common with the other members of an incorporated company consisting of more than 25 persons, shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. But subsection 4 does not apply to the office of any of the Queen's Ministers of State for the Commonwealth, or any of the Queen's Ministers for a state, or to the receipt of pay, half pay, or a pension by any person as an officer or a member of the Queen's Navy or Army, or to the receipt of pay as an officer or member of the naval or military forces of the Commonwealth by any person whose services are not wholly. The oath then becomes very important because it starts with the monarch at coronation and determines the kingdom in which all of the subsequent oaths are taken. We can look into this in more depth as we go. We should look at Letters of Patent 1900, which then in turn gives the Governor-General his power by constituting the office of Governor-General. Letters Patent 1900. The Governor-General may constitute and appoint in our name or on our behalf all such judges, commissioners, justices of the peace, and any other necessary officers and ministers of our said Commonwealth, as may be lawfully constituted or appointed by us. 5. The Governor-General may, on our behalf, exercise all powers under the Commonwealth of Australia Constitution Act 1900, or otherwise in respect of the summoning, procuring and dissolving the Parliament of our said Commonwealth. 9. And we do hereby reserve to ourselves, our heirs and successors, full power and authority from time to time to revoke, alter, or amend these our letters patent, as to us or them shall seem meet. Through Letters Patent 1900, we can see that the Governor-General may constitute and appoint those in office, including those of office that are appointed by the will of the people in elections. Commonwealth of Australia Constitution Act, Section 68, Command of Naval and Military Forces. The Commander-in-Chief of the Naval and Military Forces of the Commonwealth is vested in the Governor-General as the Queen's representative. The Governor-General was the Commander-in-Chief of the Armed Forces, although after this double kingdom situation, the role of Commander-in-Chief became dubbed as titular title and was removed from the office of Governor-General by Queen Elizabeth II under Letters Patent 1984, reconstituting the office of Governor-General. The office hasn't seen change before this, so the Governor-General, operating under Letters Patent 1900, would have had to have been operating in the capacity of the United Kingdom of Great Britain and Ireland. This is obviously questionable given the current situation and giving assent to Royal Powers Act 1953 in the first place. If you consider that through Royal Powers Act 1953, the United Kingdom of Great Britain and Northern Ireland and Her Majesty Queen Elizabeth II took powers over the Commonwealth of Australia, still under the Imperial Crown, and the United Kingdom of Great Britain and Ireland, as defined in the Acts Interpretation Act 1966, until changes under Queen Elizabeth II in Acts Interpretation Act 1973. Did the Governor-General give royal consent to the demise of the Crown? When this change to the Acts Interpretation Act occurs in 1973, of key importance is the removal of the Commonwealth of in the title of Australia, and that the Queen is no longer referred to as Her Most Gracious Majesty the Queen, and merely the Queen. We know the Letters Patent 1900 constituting the office of Governor-General from the first line of the letter which Kingdom of Office sits under. We also see that Queen Victoria presents these letters to all who read them. Queen Victoria, by grace of God, through the blessing of Almighty God, constitutes the office of Governor-General under the Commonwealth of Australia Constitution Act, July 1900 UK PGA. Letters Patent 1900. Victoria, by the grace of God of the United Kingdom of Great Britain and Ireland, Queen, Defender of the Faith, Empress of India, to all to whom these presents shall come greeting. 9. And we shall do hereby reserve to ourselves, our heirs and successors, full power and authority from time to time to revoke, alter, and amend these our letter patents, as to us or them shall seem met. We can see very clearly the letters patent issued by Queen Victoria constituting the officer of Governor-General comes under the United Kingdom of Great Britain and Ireland. From letters patent at section 9, we can also make note that the powers are reserved to heirs and successors only. Dated 21 December 2001. Letter from Kevin Davidson, Senior Advisor to the Governor-General, to Mr. R.G. McCulloch. Dear Mr. McCulloch, thank you for your letter of 17 December 2001 to the Governor-General concerning the Governor-General's role as Commander-in-Chief of the Armed Forces and the current situation in Afghanistan. Dr. Hollingsworth appreciates the time and trouble you have taken writing to him about inquiry. However, the title of Commander-in-Chief held by the Governor-General under Section 68 of the Constitution is a titular command, which does not entitle him to intervene in the administration of the Australian Defence Force. Under promulgated administrative arrangement orders, the Minister responsible for the administration of the Defence Force is the Minister for Defence, and it is an integral part of the established constitutional conventions of our parliamentary democracy that in such matters as this, the Governor-General acts upon the advice of the relevant minister. Therefore, may I suggest, if you wish to pursue this matter further, that you approach the Minister for Defence. Yours sincerely, Kevin Davidson, Senior Advisor to the Governor-General. Letters Patent 1900. Number 2. There shall be a great seal of and for our said Commonwealth, which our said Governor-General should keep and use for sealing all things whatsoever that shall pass the said great seal, provided that until a great seal should be provided, the private seal of our said Governor-General may be used as the great seal of the Commonwealth of Australia. We can also see very clearly that Letters Patent 1900 issues initial provisions for a Great Seal of the Commonwealth of Australia, and that it is to be vested in the Governor-General under appointment of the United Kingdom of Great Britain and Ireland. We can also see very clearly that the Queen took the oath to the United Kingdom of Great Britain and Northern Ireland, and subsequently needed Royal Powers Act 1953 in which to take powers within the Commonwealth of Australia. We can also see that the Governor-General is to commission or appoint various roles within the Commonwealth of Australia under the Constitution Act through letters patent issued under United Kingdom of Great Britain and Ireland. We can also see very clearly that this is done by oath of allegiance, and that all officers constituted under the Commonwealth of Australia Constitution Act required by oath that allegiance, and in many circumstances extra oath by way of oath of office. We can also see the United Kingdom of Great Britain and Ireland was still so named in the Act's Interpretation Act 1966. Although Queen Elizabeth II, by Royal Powers Act 1953, became monarch to the Commonwealth of Australia through a United Kingdom of Great Britain and Northern Ireland at coronation in 1953, claiming reign over Australia post-Imperial Conference 1926. Interesting to note is when Queen Elizabeth II entered Old Parliament House in 1954 to officially open Parliament, there is a red ensign hanging beside the Union Jack. It can be defined as red against the cross of St. George on the Union Jack flag. When Queen Elizabeth II entered the original Parliament of the Commonwealth of Australia in Melbourne, Victoria, currently used by the Victorian State Parliament, she sat on royal chair under clamshell, with Shield of United Kingdom of Great Britain and Ireland in her upper left, and Shield of the City of Melbourne to her upper right. In front of her is a sceptre of the Parliament, an imperial crown embossed in the woodwork. On the foyer floor, upon entering the Parliament, lies the royal arms of the United Kingdom of Great Britain and Ireland, encircled with the words, "Where no counsel is the people fall, but in the multitude of counsellors there is safety." After passing the foyer, you enter into the Queen's Chamber. A statue of Queen Victoria stands centred between the two Houses of Parliament. The same could be said of Old Parliament House in Canberra, wherein a statue of King George V stands in the King's Chamber, centred between the old Senate chambers and the old House of Representatives chambers.